Thanks all for attending, and here we go. Um, if we can move forward to the introduction screen, Ryan. And by the way, apologies if I'm coughing away here. I'm unfortunately sick with the plague today, and I'm going to do my best. So, just to introduce myself, many of you have attended my webinars. I'm a partner in the advertising group, focusing in all manner of things, including promotions and consumer protection, a little bit of antitrust, which we'll talk about today since it's come up in this area, and lots of pricing questions. Ryan joins us, Ryan Lapine, from our California office, where he's an accomplished litigator. And we have been working together on a number of pricing issues and pricing class actions, which is where we decided that we would schedule this webinar because we're seeing a increase in the number of class actions, particularly coming out of California. And so this is very much an of the moment issue. So let's go. In terms of the agenda, we're going to talk in particular about deceptive pricing laws in general and the FTC and the state, comparison pricing, dynamic and algorithmic pricing, which we've seen a lot of issues coming up there, drip pricing and junk fees, and then sort of some best practices to wind up. So retailers today have grown increasingly sophisticated in how they're pricing, how they're allocating merchandise, using data, and in generally collecting information and then using it for pricing. Many retailers now we find are using the data they're collecting to sometimes use dynamic pricing, automatically pricing their products. But the problem is that the federal and state laws are sometimes not often up to date with the sort of advance of pricing practices. And so we're running into a lot of questions and a lot of legal issues where it comes to pricing. So this webinar in part is supposed to sort of try to discuss the match and the mismatch, as well as recent developments at particularly the federal level when it comes to some of this attempt to catch up in the law. So let's move on. When it comes to the federal and state laws, we're looking at, of course, the Federal Trade Commission, the Better Business Bureau's National Advertising Division, and then state laws, all of whom have statutes, regulations, guidance, sometimes informal, formal guidance on pricing. So we've got everything from, FTC guides on deceptive advertising, and NAD cases, all covering how to price properly. These laws and regulations govern everything from savings and low price claims to free goods and gift advertising, to reference price advertising, which we're going to spend a considerable amount on today, to antitrust and minimum advertised price policies. So now we're seeing more and more. The DOJ has in fact gotten involved when it comes to some of these practices, and lots of privacy as well. Now we're going to focus on sort of the deceptive pricing side of things. Next slide. First and foremost, of course, it's important to consider the laws that govern deceptive pricing claims, or rather disclosures and savings claims. Any advertisement, of course, must disclose clearly and conspicuously material terms. And material terms, when they affect pricing, can be particularly important. When we're talking about a pricing claim, often there are restrictions as to time and place. What's the relevant trade area when you're making a comparative price claim? Are you comparing to your own former price or your competitor's price? A comparative price often must not appreciably exceed the price at which substantial sales of identical or near identical products were made. So, is it an identical product? Are you comparing to something that's close, and how is it different? What period of time are you comparing to? Sometimes you have to very specifically lay that out. Um, so you need to be aware of that, and aware, of course, you need to be careful to follow the rules at the state and the federal level for making a clear and conspicuous disclosure. We're seeing a lot of general unfair and deceptive trade practice claims, and you're always vulnerable to that when it comes to pricing. And so it's important to remember, for instance, that like, the states and the FTC abhor tiny print, mice print asterisks type disclosures. And so, is it possible to make your qualifiers in the main body of an ad? What kind of disclosures are required in any kind of pricing claim, and are you making them? Now we've got the FTC talking about dark patterns. Are you doing something that could be a dark pattern? So that's always something to consider, not only what is required to make your truthful and non-deceptive pricing claim, but are you making it in a sufficiently clear and conspicuous way? Next slide. Free gifts, coupons, and rebates. One type of pricing claim is this idea of it's free. That's something that there's a specific guide on. It's only a gift when it's truly free. And it's not free if the regular price is going to be raised, or if the free product you're offering is actually, of a lesser quality than it normally would be, or you're getting fewer than you normally would. There's also a very specific kind of rule if you're offering, free, buy one, get one free, or the like. You're not allowed to offer, it's supposed to be a time limited offer, and you shouldn't have more than a few, and you shouldn't have them more than 6 months out of a 12-month period. And you should let 30 days elapse between these free gift offers or BOGO offers. So it's important to be aware of the rules that are in the FTC guide concerning the use of the word free and similar representations. We'll talk about them later, but there have been a few cases in sort of the pricing area where companies have gotten in trouble for having a continual free offer, because of course it's not free if it's always being offered. It's not, it becomes essentially a combination product if it's always a buy one, get one free. In addition, with coupons, if you're always offering something where somebody's getting a coupon for something, again, it essentially just ends up being that price. If it's always 50% off, it's actually just that reduced price. There are also a number of laws governing coupons, what kinds of disclosures are needed in certain states. Same goes for rebates. And so it's important to be cognizant of, for instance, are you in a state like Connecticut and Rhode Island, where if you're advertising a price net of a rebate, essentially you're responsible for giving that rebate at the point of purchase. So next slide. One of these cases, like I'm talking about with the forever coupons, is the Michaels case. Michaels has gotten in trouble twice over a period of 12 years for its forever coupon. People may be familiar with and even love the coupon where you can always get 20% off framing. Best Buy, not Best Buy, rather, Bed Bath and Beyond always had a similar coupon. If it's always available, then it's just 50% off is the actual price. In Michael's case, in the first case in 2011, the New York Attorney General pursued a case with Michael's. 104 weeks they found was the longest period where this coupon ran. So ultimately, the settlement was for $1.8 million, which is a hefty one. I'm going to turn this over to Ryan to talk a little bit about the current case.
I appreciate that. And I love a good forever coupon myself. Unfortunately, as we see in the second Michael's case, and in some of the cases we're going to talk about this morning, certain states almost expressly prohibited this practice, such that if it's offered, you're facing liability under a number of statutory schemes. So in the case that was filed most recently against Michael's, the plaintiffs have evoked two very relevant statutes we're going to talk about a little bit this morning. The first is California's false advertising law, and it provides that no price shall be advertised as a former price unless the alleged former price was the prevailing market price within immediately preceding. And the California Legal Remedies Act prohibits advertising goods or services with the intent not to sell them as advertised. It prohibits false or misleading statements of fact concerning reasons for existence of or amounts of price reduction. The FTC has jumped in on this as well. In 16 CFR section 233.1, the FTC prohibits an artificial inflated price for the purpose of enabling the subsequent offer of a large reduction off that price. And rather hilariously, the 2024 case is proceeding. We don't know how it's going to be resolved, but there's a table in the complaint, and very good plaintiffs' counsel were actually opposed to them in a case right now. They dot their I's. There's a date of January 9th, 2021, which gives you 20% off all regular purchases. Then again on March 16th of 2021. Then again on April 10th. Then again on May 3rd, June 29th, July 13th, the 7th of August, the 20th of September, and the table just keeps going. The allegation in this is there's really not 20% off. The 20% off price is actually just the price. And interestingly, as Melissa mentioned, this is something that Michael's ran afoul of in 2011. So to find them here again is interesting. I want to go back to that same period of 2011 on our next slide. Actually, we're going to get there in a bit. I want to talk about the FTC guidelines. The Federal Trade Commission has actually issued guidelines against deceptive pricing. And they prohibit various types of deceptive reference price comparisons or offers when advertising. And reference prices simply are like what we just talked about with Michael's, where you would say, it used to be $30, but now it's $15. And these regulations relate to comparing the sale price to a former price. It has to actually be the former price, and that's codified in several states. To a competitor's price, it actually has to be the prevailing competitor's price. And we'll hear about a case proceeding right now in which, that's really being questioned. If it's a suggested retail price, was that in fact the price that was actually charged? There cannot be deceptive bargain offers. You can't say that there's a sale of 20% off, for a limited time when it's really not for a limited time. And then we're going to see in a rather interesting case, miscellaneous price comparisons. What are you actually comparing the price to? With regards to former pricing, again, that's 16 CFR section 233.1. The Federal Trade Commission prohibits the use of fictitious former prices. A former price is bona fide if it was offered to the public on a regular basis for a reasonably substantial period of time, honestly and in good faith. And look, I can pick up my phone, and for a very long time, this type of phone was offered for a particular price at a particular retailer. It's pretty obvious to say what the price is there. But I can pick up maybe my water bottle, and maybe if it was for a day offered at price X, under the FTC regulations, that's not a bona fide former price if it immediately went down. And competitor pricing, and we're going to see this in some of the cases we're going to talk about today. Uh, if you're going to compare to a competitor, the price cannot appreciably exceed the competitor's price. The price has to be based off of substantial sales of the product. Despite sales must be in the advertiser's trade area. So I can't say I'm 20% cheaper than my competitor if in reality I'm selling in Ohio and the competitor I'm talking about was selling in Hawaii, where perhaps prices across the board are higher. The price must also be reasonably certain. Again, going back to the example of the phone, we can reasonably certainly say what that phone was offered for an extended period of time. If you're talking about competing products or similar products, that needs to be made clear as well. So if I'm not selling this phone, but I'm selling, a different type of phone, that needs to be clear in advertising to not run afoul of the FTC regulations. And I'm going to pass the baton back to Melissa.
Sure. Going back to these guides, the FTC has a guide talking about the use of suggested retail pricing, which is sometimes called things like manufacturer's list price or list price. Essentially, these govern the concept of a non-deceptive use of manufacturer's suggested retail price versus deceptive use. And so these requirements are that the MSRP must correspond to a price at which a substantial number of sales of the same product were made. And you're going to hear these concepts again and again as we talk about the cases and also the state standards, which often follow this idea. The sales must be in the advertiser's trade area. The price should be set in good faith, um, uh, which is partially a recognition that the trade area can be difficult to investigate. Often for a national retailer um, or a national manufacturer, the trade area is, well, the whole country, and so it can be hard to set and then keep current a national market. And so, there's a recognition there with the Federal Trade Commission, with the state standards, that it should be a good faith price, but that if, it's a very volatile market, then um, it may not always be 100% accurate. That being said, to the extent that it's a very volatile market, there's also the concept that sometimes it may not be appropriate to use these suggested list prices as a technique where, say, the list price will go up and down frequently. There are certain industries where that price just changes all the time, whereas, furniture, clothing, the like, it tends to be more less volatile. These standards apply to national or regional manufacturers and distributors. It includes mail order and catalog. And also there's a recommendation in there that the local retail should look to the sort of principal stores or retail stores in their area for reference. It's not necessarily every single store has to be evaluated.
Hey, Melissa, before we move on to the next slide, we've got a question, and that is, how is trade area determined for purposes of FTC analysis?
Sure, it's basically what market do you sell in. So again, if you're selling nationally, then it should be national. If you sell only in the northeastern market, then you would look there. Now, there's also a recognition that sometimes you should, if there's a huge variation in between the markets you sell in, perhaps particularly in the sort of internet age where you're advertising online. Perhaps you should be, considering targeted ads with different list prices. So, there's different ways to sort of approach this if you're concerned that the list price may be very, very different, or the appropriate list price may be very, very different in different markets. Okay, bargain markets, bargain offers. One type of bargain offer that we talked about was and I think the classic one are these ideas of buy one, get one free, 2-for-1 sales, half price sale, penny sales. The guide concerning the use of the word free and similar representations we talked about before, in some detail regarding timing, how often you can really run it in good faith, and within the guidance. One of the most important things to remember, though, is that you should not be using bargain offers where you are reducing the quantity of the product in order to offer it. Unexpected strings are attached, other than requiring purchase. If you're charging something other than the price of the product in order to get the free offer, that's probably the area where people are getting in trouble the most. Is shipping and handling okay? Yes. However, if you are bundling some of the cost of the original product or the free product into that handling, then that's an invitation to trouble with the regulator. There is an expectation there may be some reasonable handling cost, but you shouldn't be recovering some of the price there. And there have been a number of cases in that area. And of course, disclose all the terms and conditions to the offer. Other miscellaneous pricing offers. You can't call something wholesale if it's really just the retail price. Factory price, calling something factory price or outlet price. There's actually been quite a few cases in California, class actions, where retailers have called something the outlet price, and that's not true. It's just a price that's been specially set and sold in outlets, but it's not like it's secondhand, or it's would have been sold at retail, but it wasn't purchased or something like that. Offering imperfect or irregular prices when it's without sort of saying this is higher than regular. Advanced sales, or sort of introductory sales have special terms and conditions. Limited time offers, of course, you have to disclose the expected dates. And sort of there's various different types of offers. It's actually, there's a BBB guide on these as well that's sometimes helpful, but it's really the FTC and its deceptive pricing guides that has clear guidelines.
Hey, Melissa, before we scroll forward, we have another question from an attendee who asks, what do you suggest for companies seeking to determine substantial sales in the trade area? Companies often complain they can't easily determine this information.
I'm going to talk about that actually probably in the next slide. So let me put a pin in that one, and let's talk about the state laws, because that's where they really get into the nitty gritty of that one. The Federal Trade Commission standards, sometimes there's guidance in the comments and in the cases and settlements. The FTC tends to make a lot of law through settlements, and they often will, update their guides. They may provide FAQs, they may provide guidance and commentary, and it's always helpful to look on there to see if there's been something. But then there's also, in this area in particular, one of the things that makes it so difficult to come up with a 50-state strategy is that state laws can vary considerably on pricing. And sometimes they can get very specific. This can make it difficult to come up with a 50-state strategy that guarantees compliance in every state. Some of them are very general and generally follow the FTC standards, but then you get laws like some of the specific laws that I've provided here, and we'll talk about as we get into some of the cases as well. So Georgia just says that, for instance, you can't advertise an item for sale until that item has been, has been offered at the regular price, or, the comparative price for the past month. You essentially, with Georgia, if you want to come up with a safe comparative, a safe strategy that's comparing something to your former regular price, you have to have it on being sold for the regular price for at least a month. One of the things that comes up with sort of reference pricing or former pricing, as we've talked, as the question was about, is sort of, okay, well, how long do we have to offer a product at the regular price? And does there have to be, or how many actual sales do we have to make at the regular price? Because often, nobody buys retail anymore, shall we say. So there's at least the perception, if not the actuality, that you're not going to make sales at the full price, and nobody's going to buy until the price comes down to whatever sale price. So that's the idea in Georgia, that you need to have something that is offered at that regular price for at least a month, without referencing whether there are actual sales being made at that price. Connecticut looks at whether you were actually selling the product for at least 90 days preceding the date at which the price comparison is stating, or you disclose the time period at which sales were made. So a little bit easier in the sense that you can actually say, this was the price that was offered, your regular price offered in January, or you were offering that for 90 days before putting it on sale. Missouri, on the other hand, has probably the most restrictive standard in the country, where, it depends on how you look at it. They say you can't make a price comparison unless it's an actual bona fide and not illusory price, at which reasonably substantial sales were made in the regular course of business and on a regular basis in the immediate recent period. So they look at substantial sales, actual sales, but they provide a rebuttable presumption, unless you can either show sales of 10% or more, not less than 30 days before the sale or more than 12 months before. So it's a rebuttable presumption, but it's very specific. There's actually an offered at standard as well, if you can show that you offered the product for more than 40% of the previous 12 months as well at the regular price, which is a long time. So you can see how these standards are very restrictive. We've come up with sort of we think most of the time you should comply standard nationally, but it's difficult to come up with that, which is actually about 36 days before the regular price. And then for sale, you can only put it on sale for so long as well. California is tough in that it has its own standard, which is the prevailing market price standard. It says, for the purpose of this article, the worth or value of anything advertises the prevailing market price, which is wholesale or retail, depending on where the offer is being made, at the time of publication in the locality where the advertisement is published. So again, if it's a national ad, look nationally. If it's local, look locally. And then you look at, was the alleged former price the prevailing market price as above defined within 3 months immediately preceding the publication, unless the date was clearly, exactly, and conspicuously stated in the advertisement, meaning the date at which the price was prevailing. And then, in other words, the retailer must ensure that the original price being referenced was the prevailing market price within 3 months prior to the publication of the advertised price or some other disclosed period. Restrictive standard. We're going to talk about how that has been challenged, or how pricing by specific retailers has been challenged under that standard in case law now.
Before we go any further, I want to give everyone our CLE code. And our CLE code is going to be Pitfalls 2024. That's PITFALLS 2024. So we talk about these restrictions, and when I'm talking about the advertising laws with Melissa, sometimes, my heart races because I think how many different traps sellers of goods can fall into. But oftentimes you see in the cases that there's some sort of obvious failure that led to the particular entity being ensnared in these advertising laws. In the California versus Overstock.com cases illustrate this point quite well. Hilariously, Overstock advertised a patio set on sale for $449.99. Sounds fine. And they said that there was a list price of $999. Well, a consumer bought it, and Overstock omitted taking off the retail sticker of this patio set. And the retail sticker said that it actually cost $247, which was less than what Overstock charged and much less than the list price. And similar instances led to 8 district attorneys in California in different counties filing suit against Overstock in 2010, claiming that they were inflating the list price in their internet sales. And it turns out that they were doing this in 3 ways. What Overstock was doing was we talked about this earlier, they were comparing non-identical goods. And we talked about my phone. So, they would say that the list price for phones is X, but they weren't comparing the same type of phone, which created a higher list price. Secondly, they were scouring the market to find the highest possible price. And so, when you're driving around for gas, there's always going to be one gas station that's $2 a gallon higher, and you don't sort of really know why. They were looking for that proverbial gas station with all of their comparison pricing, and it turned out not to really be reflective of the market. And finally, they were engaging in a formula where they were simply multiplying what they were charging, and saying that multiplier was the list price. What's interesting here, though, is notwithstanding all of these pricing gimmicks, and notwithstanding furniture that arrived with the retail sticker much lower than what Overstock.com sold it for, and what it said the list price was, what the undisputed evidence in this case found was that, in fact, Overstock really was offering the lowest price. And the court found, therefore, that the misconduct was moderate. And yet, Overstock was fined $6.8 million in civil penalties. Again, this was brought by a consortium of district attorneys. And so the trial court really struggled with this. And what the trial court said was that the offending practices, they were numerous, they were persistent, and they were willful. And that this was a advertising scheme designed essentially to mislead. And the court looked at 3 ways of assessing penalties. They evaluated whether they were going to go the number of Californians who saw the offending advertisements as each violation, because the relevant codes gave a fine per violation. They thought, well, maybe it's the number of sales made through pages, or the third way they thought was the number of days Overstock violated the statutes. And ultimately what the court did was it went with the third approach, and it went with they gave a violation per each day. And it could have been a lot worse if they would have done the number of sales and the number of viewers. Take the 6.8 and put a few zeros after it. And for one period of time, they did $1,000 penalty for using the formulas, $1,000 penalty for using non-identical products, and $1,000 penalty for comparing to the highest possible price in the market. And at some point, Overstock's like, wait, the formulas this is deceptive. So they stopped doing that. Another period, it was just $2,000 a day, but also they fined them $500 per day for, quote, the lack of controls that led to the various abuses, which anyone that follows college sports reminds me of lack of institutional control, which is always levied on colleges that simply let people run amok. And the finding here was they really just weren't monitoring their sales. They, the company, the C-suite, was not monitoring the sales and advertising practices. Obviously, Overstock fought this. The plaintiffs in the case, the different counties were hoping for a higher number, but 6.8 is what it came out to. And there's some real takeaways here. One, if you're going to say that something's a comparative price, take off the sticker that shows that it's not. But also, you can't just create formulas and multiply your item times a multiplier and say that that's a comparison price. You can't go shopping for the highest price in the market. You really need to look at what everyone's selling this phone for. And finally, when you're doing comparison pricing, you can't compare non-identical goods and pass them off as identical prices. So that was what happened at Overstock. And a year later, things got even worse for JCPenney. JCPenney, great retailer, has their own brands, right? So they're proprietary to JCPenney. He would write down original retail prices, and then they'd be marked down. But even more so, you'd get a receipt from JCPenney, and it would have at the bottom your total savings today. And folks like that. Folks thought, I'm saving a lot of money shopping at JCPenney. This is a good deal. And it was alleged that this was all simply illusory. And in fact, and this is a quote that I love, the CEO admitted that for years, JCPenney really just wasn't charging the retail price. And the quote was, "So you see here, nothing was bought at regular price, fewer than 1 out of 500 units," end quote. So if you're selling 499 units at a sale price, and you're selling 1 unit for regular price, that's just not a sale price. And particularly problematic in this case, I think, was the fact that they were there using store labels. So these aren't items that you could buy at Sears or at Dillard's or at another retailer. JCPenney really set the market. And in this case, the plaintiffs went after the JCPenney Corporation under the unfair competition law that's codified in California Business and Professions Code 17200. And 17200 outlaws unfair or unlawful business practices that tied into the FTC regulations, ties into the false advertising law, but it calls for the disgorgement of profits or unjust enrichment based on the false advertising. So really what the plaintiffs were going for here was a disgorgement of all profits off of JCPenney's private label over an extended period of time. Listen, JCPenney's maybe a little bit smaller now than it was before. That's a lot of sales. It's a lot of sales. And they also added in, and I love this, and you're going to see this in a lot of cases, the false advertising law, but also the California Legal Remedies Act. And if you don't practice in California, you would say, why would they even add those claims? It awards profits. Well, the California Legal Remedies Act, the CLRA, awards reasonable attorney's fees. So take whatever your profits are and add the cost of paying the other side's lawyers. If you get tripped up in this, the cost can be high. Which brings us to Full Beauty Brands. And full disclosure, this one hits close to home because my sister was a buyer for years at Full Beauty Brands. Full Beauty Brands is a catalog company that's been around forever that makes clothes for people of all sizes, plus-sized. They've got multiple different catalogs and ended up with an entity called Eloquy. And what you're going to see here is strikeout pricing. and you can see it on the slide for the faux leather moto jacket. And they say $149.95, but with this 40% off code, it's $89.97. And the allegation here, and this is a new case, it was filed in the Northern District of California on June 13th. The allegation is that the prices were misleading because this really wasn't a discount. They were just selling it Eloquii, which is under the Full Beauty Brands umbrella, at this price. And the complaint provides lots of photographs and other ads similar to this faux leather moto jacket, showing that this 40% off appeared perhaps for longer than it should have. And it is a case, again, that goes after the California statutes that disallow advertising things as being discounted if, in fact, there wasn't really a bona fide and substantial sale for a period of time before the sale was marked. I'm going to go back a little bit in time to TJ Maxx. And TJ Maxx, national retailer, and you often at TJ Maxx would see these compare at stickers. And what was meant by compare at? And the complaint in this case was fantastic. The lawyer said plaintiffs shop at TJ Maxx because the company promises that they can get brand name products for up to 60% off department store prices. And, it's to get a deal, supposedly. But there's an allegation in the complaint that's just startling. And they say, had plaintiffs been savvy enough and stopped their shopping to get to a computer, log on to defendant's website, navigate to the bottom of the web page, find the compare at pricing link in the fine print on the left side, and click on the comparing pricing link, they would find, and the explanation on the website is the compare at prices are buying staff's estimate of the regular retail price at which comparable item in finder catalogs, specialty or department stores may have been sold. Okay, so lots of problems here, one of which is none of us are ever taking a computer into TJ Maxx to go into the fine terms on the website. But even supposing you can do that on your phone, this goes against what we were talking about earlier with the FTC regulations. We're talking about comparable items. It has to be the same item. That's an estimate. You can't estimate. If you're going to say it's compared at something, it has to be the comparison, right? You could say this phone compare at X amount of dollars, and maybe it was sold, at a retailer at the mall for that price for an extended period of time. That's fine, but you can't guess. And because they were guessing here, they ended up settling for $8.5 million, and probably do things a bit differently now, although I don't know. We're going to talk a bit about Burlington Coat Factory, and this one is another compare at. And one of the things here that was important is that the compare at price wasn't representative of substantial trades of that product in the trade area. And look, again, going back to what I talked about earlier, there's always a gas station that's going to be $2 higher. We have it here in Los Angeles. I'm sure Melissa can find one in DC. Everyone knows where it is. But you can't say that gas prices in Los Angeles are $7. That's not representative of substantial sales of that product in the area, even if it is a product sold at that price in this area. And Burlington Coat Factory was alleged here in the Central District of California of comparing at things that just weren't representative of substantial sales. And they ended up settling for $27.5 million. I'm seeing a lot. The question is, could you address the regulations that may restrict a global company from listing prices on its website? Does it need to be the price everywhere? And I will turn that one over to Melissa.
Generally, companies will have different websites for different parts of the world, because there's translation requirements for different countries. So automatically you need to start at least breaking down into sort of Spanish, French, US, hopefully Japanese, but different languages, and have differently accessible. There are often different privacy requirements. There are various different requirements. The laws can vary quite a bit. around the world. It's definitely a good idea to get counsel, and we're always happy to put in touch with counsel for different countries because the laws can vary significantly for different countries when it comes to everything from pricing to sweepstakes to privacy. So it's, it's complicated. We also had a question of, do you have to comply with the laws in every state when it comes to something like pricing? And the answer is potentially, if you are appealing to consumers in those states, then yes. Often you will see, a class action complaint that will have counts under multiple states' laws. Generally, the rule with consumer protection is if the state is stricter than, the federal law, then you are going to have to comply. There may not be a consumer cause of action under different states' laws, but you will always have to worry about the regulator bringing suit or investigating you. So you do need to worry about compliance if you are offering products for sale in a given state. I
And
do want to, Ryan, I think we're going to need to skip ahead to other sections because we
yeah,
will.
I was going to say there's examples in Missouri and in Georgia, but they're very similar to what we saw in California. But mostly, maybe we can talk about dynamic, algorithmic, and personalized pricing.
Yes. This is something we mentioned at the beginning is sort of the trend. This idea of using data in some way to automate your price changes or at least to set your pricing based on things like demand, customer behavior patterns, factors based on that demand. It was already a thing prior to the pandemic, but since then, it's become, huge as we collect more and more data about customers, what they're buying, how much time they're on a website, how much time they look at something. That's being then put to work in determining how to price things. And it helps, it ultimately has a customer positive effect in the sense that companies are able to lower and increase less, perhaps customer positive prices in a way that helps the company retain the margins they need while hopefully giving customers what they want as well. It is, however, under the microscope by the Federal Trade Commission, by the Department of Justice, and regulators generally who are looking at it. It was just in the news in a story about surveillance pricing, which we'll talk about in a second. But like we found out from one e-commerce retailer that reportedly changes its prices millions of times for millions of items every few minutes. Airlines, hotels, ride sharing platforms, reportedly 15 to 20% of sellers are using it. So next slide. Some of the issues that come up here with the idea of personalized pricing and the OECD, which is an international group to respond, a little more information on that front, has put out a paper on it, personalized pricing in the digital era. And there is an obvious privacy issue to the extent that consumers have not given permission for their data to be used this way, don't expect it, then that's a privacy issue. And to the extent that a regulator has not sort of okayed it, I think some of the European countries are looking at it as well and may have a stricter view, as with most privacy issues. So that's an important issue to the extent that you're looking at gender, income, age, and offering differential pricing. There may potentially be a price discrimination issue, particularly to the extent that you used one of what's considered a civil rights or human rights factor, like age or gender or race sex to change pricing, it may be something that presents an issue in that way. Additionally, and next slide, um, there can be issues. We talked about price discrimination, but now the government has been actively looking at whether there's a risk of price fixing. Traditionally, you may be familiar if you play in the antitrust sphere at all with the idea of hub and spoke conspiracies for price fixing based on like a trade association collecting information from different horizontal competitors, and then using that for price fixing. It's the same theory based on using a common software algorithm, says the DOJ and the FTC. They are conducting, there is an investigation right now going on where the DOJ and FTC have contributed statements and as part of that, this Cornish Adebiyi versus Caesars Entertainment case. Essentially, the U.S. Department of Justice and the FTC jointly submitted a statement of interest on behalf of the U.S. in this case, which is in the Department of the District of New Jersey, where they weighed in. It's a case involving hotel chains, and essentially the plaintiffs there have alleged that the competing casino hotels violated Section 1 of the Sherman Act by, among other things, unlawfully agreeing to use a pricing algorithm platform to set prices for their hotels in Atlantic City, which helps then to set the prices that were charged. The defendants have moved to dismiss the complaint, arguing that the claims are legally insufficient because the plaintiffs don't allege that the defendants discussed their choice of pricing software or agreed to adopt a common pricing platform. The DOJ and FTC filed the statement of interest addressing two claimed legal errors that the defendants made. The suggestion that plaintiffs must identify direct legal communications to plausibly allege a violative agreement, and the argument that a price fixing claim must be dismissed because the recommendations generated by the pricing algorithm are not binding. The agencies have said that direct communications are not required to show proof of an agreement, and that Section 1 covers tacit as well as express agreement, and that Section 1 prohibits competitors from delegating key aspects of pricing decision making. So this is an interesting case. It's ongoing, but the idea that these pricing algorithms could be used and could become part of a price fixing conspiracy is certainly something to consider in participating in something like that where your competitors may be involved. The other big development in this is an FTC subpoena that was announced yesterday, which is, or rather on July 23rd, which is discussed on the next slide. And the FTC has sent subpoenas to 8 intermediaries seeking information regarding what it's calling surveillance pricing, using authority that the Commission has under Section 6B of the FTC Act to collect information as part of a market study. But essentially, the FTC is concerned about data that these intermediaries are collecting and then making part of or pricing products or services they're offering to collect data. And then what they're doing is these middlemen are providing products to third parties like Starbucks or McDonald's or Home Depot or the like, which then helps them to do a variety of things, that have to do with use of pricing data, um, uh, or to price products and services and the like. This is not uncommon for the FTC to do these kinds of market studies, but it is something that shows you again that the FTC is very interested in the privacy side of this idea of the use of data to set pricing, to conduct dynamic pricing, that sort of thing. So ultimately, the FTC is looking at what kinds of products and services they're offering, what they're collecting, and how the data is being used to target consumers and how it impacts. The companies involved right now are things like MasterCard, JP Morgan, Revionics, which is part of Goldman Sachs, and the like. And they work with the retail, hospitality, travel, finance, home goods, and restaurant industries to help with pricing and the like.
Melissa, I'm going to jump in here and remind our participants that our CLE code is Pitfalls 2024. Again, that's Pitfalls, Pitfalls 2024. And we are running down to the end of our time here. So I think maybe now we might want to conclude that, first of all, we had many more slides that we'll probably present to you at a later time. There have been many questions if the slides could be made available afterwards. I think Kate has answered that in the chat. And look, we're seeing a proliferation of reference pricing lawsuits across the country. It is a hot item right now. And, we're also seeing a proliferation of this dynamic pricing that Melissa was talking about. And if you were to study economics 20 years ago, this was the dream. You could find out what every consumer was willing to pay. And it seemed fanciful. But now that we're here, the FTC is looking much more closely at it. And it'll be interesting to see where the FTC and where the states go with that as they regulate pricing to ensure that consumers are not misled into believing, on the one hand, that they're paying a discount when that's the actual price, and on the other hand, that their private information isn't being used to target them and treat them a bit unfairly as compared to other consumers in the market.
Yeah, and Ryan, why don't you jump to the very last slide? But also, we did have several slides on the junk fees issue, which was covered in detail, however, on the another webinar that was given about 2 months ago. So if you're interested in that issue, I would recommend that you pick up that webinar off our website and listen to that. There have been a few new developments on that, but that's a very comprehensive basics on the issue, and not just basics, but sort of dive into that issue. And you can continue to follow it as it develops on our blog, which is allaboutadvertisinglaw.com. So for more information on all of these issues, you can follow along on that blog.
And we really appreciate all of you joining us today on a Tuesday afternoon.
Thanks very much.